a Supreme Court author, the Supreme Court gave a major decision on the rights of the daughters in their father's property. Supreme has delivered an important ruling regarding daughters' rights to their father's property. In a significant judgment, the court stated that if a person dies intestate in a joint family, the daughter will have priority over the sons of his brothers in inheriting the father's property. This rule will also apply to the property partitions that took place before the enactment of the Succession of 1956. Right? The Supreme Court gave this important verdict in a property dispute from Tamil Nadu ruling in favor of the daughter's legal heirs. Okay, a bench comprising Justice S. Abdul Najin and Justice Krishna Murari in its 51-page judgment set aside the decision of Madras High Court, which had granted rights over the father's self-acquired property and his share in the partitioned property to his nephews. The father had died intestate in 1949. The Supreme Court has now clarified that in such a way that the sole daughter has the okay, equal rights of daughters in father's property. That is, the Supreme Court clearly stated that Hindu Succession Act 19 Act grants daughters equal rights and with sons in their father's property. These rights apply to both ancestral and self-acquired properties. The court further reiterated that if a person has no son, his property should devolve upon his daughter rather than his brother's son. Okay, then the judgment strengthens women property rights, which were religious and customary laws. So the Supreme has now extended this principle to property partitions that occurred even before 1956. This ruling may have a specific impact on several pending property dispute cases in law and lower courts across the country.